Hello everybody, this is Dr. Cole, and this will be the video for week 2 of American Constitutional Law, POLS 3753, I believe, week 2 for the fall term of 2024. Okay, everybody, this week, among other things, we have a discussion. This announcement is going out on Sunday. The discussion will be Monday and Tuesday, the 26th and 27th. And then we have a quiz on the 29th. So, 2 things this week. Everybody, each of these asks you to look at a piece from the New York Times. One for the discussion and one for the quiz. And there are a couple other things assigned for the quiz. So that's 2 New York Times articles. Now everybody, that in and of itself should not be enough to make the New York Times paywall come up. I believe they let you look at 5 or 6 things a month before the paywall comes up. But if it so happens you've already looked at a couple of things from the New York Times this month, the paywall may come up. So please, 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 everybody, I will never ask you to pay for anything that you're assigned in this course. So if you're trying to reach those articles and the paywall comes up, contact me and I will get the text of that to you. Okay. Well, the discussion will be Monday and Tuesday. Some of you all may not be seeing this until Monday. Generally, people will wait until the last 24 hours to post. So even if you come up against a paywall tomorrow, contact me and I will get that material to you. And you will still be able to take part in the discussion. Okay. They're really both pretty short pieces to read. Then the quiz will be coming up Thursday. Okay. So the discussion for 48 hours tomorrow, Monday, and Tuesday. And then the quiz will be available for 24 hours Thursday. 10 items, 2 points each, 20-point quiz. 3 things to look at for the quiz. All right. Now, one thing at a time. On the syllabus for this week, we have judicial review. We have 2 sets of class notes, lectures 2 and 3, both of which are about judicial review, which of course refers to the Supreme Court's power as a constitutional court. Its power to review acts of Congress, acts of state and local governments, presidential actions, and determine whether they are in conflict with the Constitution or not. Now, as we say, we treat the Constitution as higher law. So the idea is the Constitution prevails over lower bodies of law if there's a conflict. Okay. Now, as you read these notes, you'll notice judicial review is an issue of controversy. It frequently becomes controversial. Not every country provides for judicial review. There are countries with a Supreme Court and with a written constitution that do not provide for judicial review. Some countries provide for that, others do not. In the British system, there is not judicial review. Generally, the rule is what's constitutional is whatever Parliament says. So it's kind of inconceivable to declare an act of Parliament unconstitutional. But that's a different system than ours. So some countries provide for judicial review, others do not. The United States does. Now, the constitutional language is ambiguous. You might think that the constitutional language implies that the Supreme Court shall have the power of judicial review, and they eventually claimed it, and it turned out that that was accepted. But for the first 10 or 15 years under the Constitution, that might not have been completely clear. And what happened, of course, was the case of Marbury versus Madison, and basically what happened in that case was we were in the aftermath of the 1800 election, which some people say was as acrimonious a time in American politics as we are having now. Okay, when the Federalists under Adams were defeated and Jefferson came in, predecessor to the modern Democratic Party. Well, Jefferson was the kind of person who would not have thought much of judicial review or of the Supreme Court claiming that power. So what Chief Justice Marshall did when a case came up, basically what happened, the lame duck period at that time was longer than it is now. The president was not inaugurated till the spring. Subsequently, we provided for the president to be inaugurated in January after the election in November. But at that period of time, the lame duck period lasted longer, and President Adams, before he left office, nominated and got confirmed some federal judges with views opposed to those of Thomas Jefferson. So Jefferson attempted to block these people from taking their seat on the federal bench. He tried to prevent the commissions from being delivered, was what was the issue with the case. So Chief Justice John Marshall came to realize that Thomas Jefferson was not necessarily going to recognize just any ruling that he might make. It's possible that he might ignore a Supreme Court ruling. And if that situation had come about, it might have squandered the authority of the Supreme Court for all time. So what Chief Justice Marshall decided to do was give Jefferson what he wanted on the immediate issue at hand, but at the same time claim the power of judicial review. He said he could not do what Jefferson wanted because a section of the Act of Congress, the Judiciary Act, purported to give the Supreme Court that power, but that's unconstitutional because you can only give the Supreme Court additional authority by constitutional amendment. So we declared unconstitutional one section of the Judiciary Act that purported to give the Supreme Court that authority, and Thomas Jefferson had to swallow it. And it was, by and large, accepted at the time. The matter might have been resolved differently had a different ruling come down from the Supreme Court, and the Supreme Court now might not have the power that it now has. Okay, but that's how Marbury versus Madison was resolved back in 1803, I believe it was, in such a way that the Supreme Court claimed, and the rest of the government and the country as a whole recognized its power to exercise judicial review. Nowadays, judicial review is exercised quite often. But Marbury versus Madison was the first, and the second use of judicial review did not come until Dred Scott, just before the Civil War. As we know, a highly, highly controversial Supreme Court decision. It was an attempt to resolve the slavery issue, but it was not successful. And that's an example of a Supreme Court decision being overturned by a constitutional amendment. It was, in effect, overturned by the 14th Amendment, which says that all persons born or naturalized are citizens. Of course, the Civil War came in between, so you might say it was the Civil War that resolved that issue. In any case, by now, judicial review has been exercised far more often, and often it is politically controversial, of course. I've given you the remarks of several people over the years, especially going back to the late 20th century and the Reagan administration period. A couple of figures, Supreme Court justices such as Brennan, Attorney General Edwin Meese, offer their comments, and you find those in lectures 2 and 3. So it often can be controversial for the Supreme Court to exercise judicial review, and there are many questions that can be raised about this practice, as you'll see from the class notes. Toward the end of the class notes, we mentioned that one way in which the court has tried to exercise judicial review through the years is through the doctrine of substantive due process. It says the substance of a legislation may violate due process according to the Constitution. Now, an example of that was highly controversial was the Lochner case, U.S. versus Lochner, I believe, in 1905, in which the Supreme Court struck down regulations to limit the working hours and conditions for bakers. Okay. The police power does not extend that far, the Supreme Court said. Okay. Dissenters argued that the police power, the general governing power that a government has, traditionally had been interpreted more broadly than that. But frequently the Supreme Court would intervene against regulations, interventions in the economic area by invoking the doctrine of substantive due process. But as the New Deal period approached. And in the aftermath of President Roosevelt's court packing plan, after the Supreme Court had tried to block some of Roosevelt's New Deal initiatives, the Supreme Court in the West Coast Hotel case backed away from the doctrine of substantive due process. And it continued to back away from it for some time, at least until very, very recently, we might say. Okay. And there's controversy about whether the Supreme Court in the West Coast Hotel case was knuckling under to Roosevelt's political pressure. In my remarks in the lecture notes, I've tried to draw upon what the constitutional scholar Lewis Fisher has said about that. Okay. All right, then. I might also mention, when we get to the issue of abortion after the midterm exam, one thing you will see in the notes is that in Roe versus Wade, which has been struck down now, you can look upon that, you look at right to privacy as a different kind of substantive due process. Of course, that remained in place for almost 50 years before it was struck down in the Dobbs case. The Supreme Court, though, said in Dobbs they were acting with regard to abortion only and not necessarily other aspects of the right to privacy, which in itself is a highly controversial doctrine. But you can look at it as a sort of an example, a new version of the doctrine of substantive due process. All right, well, in any case, we've got our discussion and our quiz this week. For the discussion, I'm asking you to look at a short editorial from the New York Times. The election is crucial to the Supreme Court's future. Biden's reform plans or not. Okay, and what you can think about for this discussion, look at this editorial and think about the political position of the Supreme Court at the present time. Now, elections are one way in which we can indirectly check and balance the Supreme Court, because in elections we choose the president who's going to make any nominations to fill a vacancy on the Supreme Court, and then those must be confirmed by the Senate, and senators also are elected. Okay, and you might say Trump, especially with the 3 appointments he made to the Supreme Court, was doing what his supporters wanted him to do to check and balance the Supreme Court. And that's one very prominent way in which it can be done. Probably the easiest way to check and balance the Supreme Court is to appoint new justices with different views when vacancies arise. But that's not the only thing that can be done. After Labor Day, we have lectures 4 and 5 that I believe are up on the website. Lecture 4, efforts to curb the court, that is, to push back against the Supreme Court. And lecture 5, threshold requirements, about which I'll be saying more in just a moment. Now, efforts to curb the court. President Biden, after he withdrew from his re-election campaign, nevertheless had been concerned, as many of his supporters, many Democrats had been, about recent Supreme Court decisions, especially the case of Trump versus the United States, which we will be talking about later on. I've got to revise my remarks and incorporate something about Trump versus the United States. That, of course, was the presidential immunity decision. And they ruled that the president is immune from prosecution for his political acts, okay, official acts, but not unofficial acts. Okay, and John Roberts said not everything the president does is official. Okay, so probably litigation is going to go back to the court perhaps at some point to get them to interpret further the difference between an official and an unofficial presidential act. You have immunity for the one, but not for the other. Okay? But President Biden, in the wake of that, came out with some initiatives to push back at the Supreme Court. And they're probably not going to go anywhere except as talking points, because the Republicans control the Senate. And this is a partisan divide to a large extent. One of the proposals was for an 18-year term limit on Supreme Court justices, so that every president, every 4 years, would get to appoint 2 Supreme Court justices. He also wants a code of ethics that could be enforced against the Supreme Court by lower federal courts, which is controversial in and of itself, and also a constitutional amendment directed at that Trump versus the United States decision. Okay. Well, The term limits idea had been discussed before, but all of it is a sort of a way for Biden to push back against the Supreme Court. And in my remarks, which I used the writings of the constitutional scholar Louis Fisher to put together those remarks, he says there's always pushback. There's constantly throughout American history been pushback against the Supreme Court. The Supreme Court's rulings are binding until they're overturned, but we don't treat the Supreme Court as infallible, because that would be asking more of the Supreme Court than we could reasonably demand. Okay, so there will always be pushback, or frequently there will be, and more often than not, the Supreme Court will respond to that pushback. They're not completely invulnerable to public pressure. All right, so look at that editorial, and tomorrow and Tuesday discuss what you think about the current political position of the Supreme Court, especially with the addition of the 3 Trump appointees and in the wake of some of the controversial decisions they've made, such as the Dobbs decision, Trump versus the United States, and other decisions that they've made in the area of economic regulation and the power of administrative agencies especially. We'll have occasion to talk about over the course of the term. All right, now then, for the quiz on Thursday, 3 things to look at. Okay, I'm going to ask you to look at an essay by Carlos Lozada in the New York Times about it's about the Supreme Court since the Trump appointees have been added. Now, this goes back to April of 2023. So this comes before the Trump versus United States decision, but after the Dobbs decision. Okay, so his article is entitled, his essay, In Which Conservative Justices Ponder Just How Far They Will Go. Right, now, 2 other things to look at. In the textbook, I've given you a couple of pages on the decision in the case of Ex parte McCardle. And that's a decision from just after the Civil War. Now, the Constitution says that Congress can remove particular matters from the Supreme Court's jurisdiction. And that's what they did in the case of Ex parte McCardle. It was a Reconstruction-era case. And the Republicans in Congress were afraid that the Supreme Court was going to move against Reconstruction, and so they moved to try to prevent them from doing that. That perhaps has been the only time, one of the only times, in which the Congress has used that power that's in the Constitution to remove something from the jurisdiction of the Supreme Court. So read that excerpt from the case that's in the textbook and the discussion just before and after. I've given you the page numbers. What happened was the court said, well, it's in the Constitution that Congress can remove this from our jurisdiction, and they've done that, and so we have no jurisdiction. End of discussion. Okay. Now, what your authors say in your textbook is, yes, it's in the Constitution that you can do that, but maybe you should be careful about doing that, because you could end up eviscerating the Constitution. You could effectively deny people their right of redress if you do that kind of thing too regularly. Okay? All right, so look at those few pages in the textbook on the Ex parte McCardle decision. Also, we've sent you a PDF from the longer version of this textbook, the 2-volume version. If we taught this course in over two terms instead of one, made a back-to-back course like we do with world or American history, okay, we might teach you the first course from the first volume of that textbook and the second course on the second volume. But we're only doing one term, so we're using an abridged version of the textbook. But you have an excerpt from Baker versus Carr in a PDF that I have scanned and forwarded to you from the longer version of our textbook. Okay. It was attached to an email to you, and is also up on the course website in the modules area. Now, what happened here was, this is a case from 1962 in which the Supreme Court laid down the principle of what we used to call one man, one vote. People today want you to say one person, one vote. They ruled the Tennessee legislature had been malapportioned. Okay. There were counties with just a few thousand people, but the city of Memphis had the same representation as those very tiny counties, even though it was a city of hundreds of thousands or more than 1 million people today. So, in effect, they ruled in a state legislature, Each member has to represent roughly the same number of people. The problem was they got a similar case in 1948, 14 years earlier. And in that case, they said, no, we're not touching this. This is a political question. This is for the legislature, the people's elected representatives, to decide, or the members of Congress or the president. Okay, we don't touch political questions. Now, that's one example of a threshold requirement that's discussed in Lecture 5. These are principles that the court uses to decide what cases it is and is not going to take. An example, one example would be the principles of mootness and ripeness. Okay. Mootness. The court can get a case and they can say by the time they get the case, the matter has become moot. One of the first affirmative action cases involved a guy named DeFunis. Came to the Supreme Court in the early 70s. And they said, well, by the time this case has come to us, DeFunis got into law school. So we're going to treat this as a moot matter. It's been mooted by the fact that he's in law school already, although he had complained earlier that he had been discriminated against by an affirmative action program, and that prevented him from being admitted to another law school. All right. That means something has happened to render the case invalid or moot. Or a case may not yet be ripe. The court may say, well, we've got to wait for something else to happen for there to be a genuine harm such that somebody has standing to bring this case to court. Okay, that would be called the principle of ripeness. A case can be not yet ripe. Something has to happen to ripen it. So there's been a harm that someone has suffered. That's related to the question of standing to sue. Okay. The Supreme Court has decided a number of recent cases on standing. That is, to have standing, you must have suffered a harm. That was an issue in the recent case involving the so-called abortion pill. A pressure group brought the case, and the court ruled that the members of the pressure group had not suffered a harm, so they could not take the case at that time. Somebody else might have standing, so the issue might come back to the court. Now, the political question doctrine is the doctrine that certain matters are for the people's elected representatives to decide. The state legislatures, Congress, or the president. And so the Supreme Court is going to stay out of those matters. Some people say that it's a way for the Supreme Court to duck a hot potato. If it doesn't want to take the case, it can find a way to say that this is a political question. So what happened in Baker versus Carr, the Supreme Court had to find a way of maintaining that while the earlier case from 1948 was a political question, it's no longer a political question in 1962. And the decision that you read includes a long discussion of what is and is not a political question. So look at that very carefully, and there will be a few items about that on your quiz. 3 things to look at for the quiz. Expect 3 or 4 questions about each. 10 questions, 2 points each, a 20-point quiz. You have your article by Carlos Lozada, you have the ex parte McCardle material, and you have the PDF I've sent you about Baker versus Carr. That's the material for the quiz on Thursday. 24 hours to take it, 10 items, 2 points each. Then tomorrow, Monday the 26th, and Tuesday the 27th, we'll have our discussion, and I want you to look at the short editorial from the New York Times very recently for that discussion. So, a couple of things to do this week while we look at the class notes for lectures 2 and 3 on judicial review. And that'll take us up to the Labor Day holiday. And so we'll get to take Labor Day off, but we'll have more material when we come back right after Labor Day, beginning on Tuesday the 3rd, I believe. So, I hope you will take part in the discussion and do well on the quiz, the discussion tomorrow and Tuesday, and the quiz on Thursday. And then we'll have more issues to talk about threshold requirements and efforts to curb the court when we talk to you once again about a week from now at this time. So look forward to hearing your discussion remarks. Hope you do well on the quiz, and we'll talk to you again once again in about a week.